welcome to this month's episode of the immigration webinar or meeting. I'm glad that you're here today and joining us to learn more about visas for dependents, including H-4s, J-2s, and more. So stick around and you'll become an expert on all of these dependent visas. And we're doing today's episode on this type of visa because a lot of times what is overlooked are the dependent visas. There's such a focus on H-1Bs and J-1s and L-1s for the primary alien or applicant. And not so much attention is paid often to dependents, spouse, children, what they can do, what they're allowed to do, what they're not allowed to do. And so hopefully by the end of today's meeting, you'll be an expert on what dependents can do and what they can't do, and what's involved in maintaining status and continuing status, and also changing status. So without further ado, thank you all for joining us. And I'd like to give a shout out and huge thank you to Carolyn Taylor for all of her assistance every month with these presentations. And also a thank you to my son, Eric Sherman, who is also helping with some of the technical aspects of this. So let's get started. Okay, first, I thought it would be a good idea to define who was a dependent, just as a start. And so this is for purposes of green card applications and also for various visa applications and visa purposes. So let's start out with spouse. Who is a spouse? Well, first of all, a spouse is someone who is legally married to the principal alien or principal applicant. And with the term legally married, what I mean is that the marriage was legal where it was performed. In other words, whether it was performed here in the US or in Canada or India or elsewhere, as long as it was validly and legally performed there, the US government will recognize it for purposes of visas and green cards. A lot of times I'll get a question from somebody saying that, I was got married in India. Now that I'm in the US, or now that I'm coming to the US with my spouse, do we need to get remarried, or do we need to somehow register our existing foreign marriage? And thankfully, the answer is no. Again, the US government will recognize the marriage as long as it was legitimate and done properly wherever it was done. And hence, there's no need to take any other steps relating to that marriage in the US. So no need to re-register or do anything else. With that being said, it is important to note that the Immigration Service and the US government does not recognize certain types of marriages that may be recognized outside of the United States in other countries. And this would include polygamous marriages, common law marriages, or proxy marriages. Just as an example of a common law marriage, years ago, I received a call from somebody, actually a Canadian citizen, who's going to enter the United States along with his spouse. And I said, that's no problem. Your spouse can get an H-4, a dependent visa. All you'll need to do is to show your marriage certificate at the border when you're entering the US. He said, actually, we've been living together for 20 years, and it's a common law marriage, meaning we've never actually had a marriage ceremony. There's no official marriage document. It's just that in Canada, if you live together for a certain amount of time, the government recognizes this as a common law marriage. It's legal for certain purposes. Unfortunately, I had to break the news to him that common law marriage may be recognized in Canada, but it's not recognized here. So the spouse, would not be able to go to the US border and obtain an H-4 or dependent visa based on the common law marriage. So I never really heard back, so I don't know what they did. But if she wanted to enter as an H-4, they really would have had to go ahead with a marriage ceremony and become officially married in order for her to enter the US as an H-4. Now let's switch gears a little bit and talk about children and what is meant by children in terms of qualifying for a dependent visa status. So first of all, the children must be under the age of 21 and unmarried. So for a lot of things in the US, the cutoff for being a child is normally 18 years of age. But for visa purposes, thankfully, it's actually 21. So it's another 3 years. Now, children can be biological children, or they can also be stepchildren. Either one would qualify for a dependent visa. Now, lastly, prior to reaching 21 years of age, when a child is in the US in some type of dependent visa status, it's really critical that you try to plan ahead. In other words, what type of visa status will this person hold when they become 21. So careful planning really should be done. And it's not something that should be put off until the last minute, when the person is 20 years and 9 months. that's really a little late to start planning on what the future will look like for this person. A lot of times, let's say someone enters as an H-4 and they're going to college here in the US, it's really kind of a painless procedure to change over to an F-1 student visa, and that's what many people do. So again, a lot of planning, but as long as it's done early enough, it should be a seamless transfer, and so the person can continue to live in the US and then go to school as well. Now, lastly, in terms of how long a person can hold H-4 or J-2 or one of these dependent statuses, if there's a divorce, that automatically ends the person's dependent visa status. So whether the divorce is done here in the US or done back in the home country, divorce terminates the marital union and hence makes it so that the dependent spouse is no longer eligible for whatever dependent visa status they may hold. So let's say hypothetically someone is here in the US as an H-4, a divorce would mean that that person really needs to either leave the country or quickly try to figure out another visa to obtain in order to stay in the US or to come back to the US. One question I get once in a while is whether a separation, whether it's a legal separation or just a physical, in fact, separation, would make it so that the dependent spouse would no longer qualify for a dependent visa. And the answer is no. As long as the parties are still married, a separation on its own is not sufficient to automatically terminate the person's dependent visa status. Okay, so let's start out with H-4s. So the H-4, as you may know, is the dependent visa status for spouse and kids of an H-1B worker, or also other H-3, sorry, other visa statuses such as H-3, H-2B, etc. So most people holding an H visa, the dependent children, dependent spouse would be H-4. So this type of status, again, available for spouses, children under the age of 21. And then it's important to note that the H-4 is usually valid for the same duration as the principal alien's visa. So the H-4 will be valid for the same duration as the H-1B. In addition, when it comes time to renew the H-1B and H-4, they can be renewed together at the same time. So again, that the renewal period or the extension period for the H-1B also is the same as for the H-4 visa status for the dependents. Now, a question that I get a lot, of course, is can an H-4 spouse or H-4 children work in the US while they're here? So generally speaking, the law is that H-4 spouses and H-4 children cannot work in the US. The H-4 is not a work visa, it's a dependent visa, and generally speaking, it does not allow for employment. Now, for children, that's always the case. There is no employment for children, no matter what. They can do things, children and dependent spouses can do things such as attend school, whether it's university studies. They can volunteer, but only in positions that are always volunteer positions. So, for instance, at your local library, the American Red Cross, animal shelter, etc. What the type of volunteering that is not allowed and is against the law is someone who is trying to volunteer for a position that is normally a paid position. So let's say, for instance, someone wants to volunteer in a laboratory in a hospital, and that's normally a paid position. However, the person is H-4 and says that they're willing to volunteer for this position and not take any pay for that. Unfortunately, that's not allowed because it's normally a position that would be paid, and hence the US government does not allow an H-4 to volunteer for that position, even though the H-4 person has said that they're willing to do it without pay. In terms of the H-4 application process, there are three ways to become an H-4. If someone is overseas, the way to do it is to obtain an H-4 visa stamp or sticker for the passport, and that's done via the local US embassy or consulate, normally in the home country. It's that stamp or sticker that allows a person to travel to the US and to seek admission to the US as an H-4. It's in that way, it's really like an airplane ticket. It allows a person to get on an aircraft and travel to the US, or instead to drive to a US border point and seek admission into the US. The next way to get H-4 status is if you're a Canadian citizen, and this only applies to Canadian citizens, not any other person who happens to reside in Canada. So, for instance, if a person has Canadian landed immigrant status, which is permanent resident status, really similar to a US green card, that person, like everybody else, has to get a visa stamp from an embassy or consulate. So at the border, Canadian citizens can actually skip getting a visa stamp from a U.S. embassy or consulate and instead simply present themselves at the border along with evidence that they qualify for the H-4 status, and they will be admitted. Or let's say they're in Toronto and they want to fly to the US, really the same thing. They can present their documentation and be admitted as an H-4. In fact, in Toronto and certain other airports in Canada, the inspection or the interview for the visa is actually done at that airport. So it's done actually before the person would board the plane traveling to the US. There are actually US immigration offices at certain airports. The third way to become an H-4 is through a change of status. And this is for people who are already in the US in some other type of status, such as F1 student status, or maybe B1 or B2 visitor status, or really any other type of status. They would change in the US or by applying to the Immigration Service or USCIS for a change of status. They would be granted a change of status from F1 or whatever their status is to H-4. But the important thing to note is that that does change their status and it allows them to be in the US in that status, but it does not give them a stamp or sticker for their passport. So if they're anyone other than a Canadian citizen, and in the future they want to travel outside the country, they will need to obtain an H-4 stamp for their passport at a US consulate or embassy before coming back to the US and seeking readmission as an H-4. H-4 with EAD. So a couple slides ago, I talked about a general rule that H-4 visa holders are not allowed to work in the US. And while that's always the case for children, there are certain spouses who hold H-4 who are eligible to obtain what is known as an EAD card or temporary employment authorization card. Those spouses are spouses of H-1B workers where one of the following is true. So the H-1B worker has held H-1B status for more than 6 years, or that person, that H-1B worker, has an approved I-140. So I-140 is one of the steps in the green card application process. And so if either of those statements is true regarding the H-1B worker, then the H-4 spouse can actually apply for an EAD card. Now, the great thing about the EAD card is that it does allow employment in the United States with any US employer at any job in any location and any rate of pay. It's really totally unlimited. A person can hold one job or multiple jobs. A person can work full-time or part-time or a combination thereof, a full-time job and maybe a part-time job moonlighting. So they're very flexible, as you can see. Now, the EAD card does expire. Usually it expires the same time that the H-4 status is going to expire. And so it's important to note the date of both expirations. It is possible to apply for an EAD extension, like a new EAD card, as long as the person is eligible to continue holding H-4 status. The nice thing about applying for an EAD extension is that once the application is properly filed with immigration, it is possible for the H-4 person actually to continue working past the expiration date listed on the EAD while the Immigration Service processes the EAD renewal application. So that's not always the case. It's often the case. There are a couple variables that we would look at, but generally speaking, this is great because it means that there would be no interruption in the person's ability to work in the US. Thus, they would not be at risk of losing a job that they might be currently holding. Okay, so let's switch gears a little bit and let's look at the J's. As you know, J-1 visa is used for many, many different things. J-1 is used for everything from resident physicians and fellows to camp counselors and au pairs, to trainees and even some university students. So it's kind of a very flexible type visa. All of the spouses and dependent children of any type of J-1, whether it's a research scholar or a resident physician, get J-2 status. So again, children under 21 and spouses. Now, the J-1 and the J-2, folks who are in the US in those types of visa statuses are in valid status in the US as long as they hold a valid DS-2019 form. And for people who are not familiar with the DS-2019, that's the actual J-1 and J-2 sponsorship document that's issued either by the ECFMG in the case of resident physicians and fellows, or by other entities such as maybe a hospital or health system that is sponsoring research scholars, or by other private companies that may be sponsoring research scholars or camp counselors or others. The DS 2019 has an expiration date on it, and it's required that a person always have one that has is still valid. So it's something that is issued usually on an annual basis. The I-94 card, or the official evidence that the person is in the U.S. in a legal status, a legal J1 or J2 status, actually does not itself have an expiration date. Instead, what it says is DS, which stands for duration of status. What that means is that as long as the person holds a valid DS 2019, that person is considered to be in 100% lawful J1 or J2 visa status in the U.S. The J1 carries with it, or some of them do actually, what's known as the 2-year foreign residency requirement. So not all J1s are subject to this requirement, but I will say that all J1s who are in the US for purposes of graduate medical education, such as, again, residents or fellows, are automatically subject to this 2-year foreign residency requirement. Along with that, the J2 spouse and children are also automatically subject to that requirement. And as you may know, if you are a J1 or J2, or if, let's say, you are managing a program at a hospital for physicians or residents and fellows, you'll know that the 2-year foreign residency requirement means that when the person is done with their training, which can last a maximum of 7 years, they're required to return to their home country for a period of 2 years before being eligible to come back to the US, either as an H-1B or to obtain a green card. The 2-year foreign residency requirement, just as a side note, means that they have to go back to the country of their last permanent residence as listed on the DS 2019. So that is the country that controls. If a person goes to a different country for 2 years, that does not fulfill the requirement. Once in a great while, I will receive a phone call from someone who is not a client, but is advising me that, they're actually from Argentina, let's say, but that they went to Canada for 2 years and now they're ready to come back because they have fulfilled the 2-year requirement. Unfortunately, I have to break the bad news to them that because they did not go back to Argentina, their 2-year stay in Canada did not count. It did not help them, and they are still subject to that 2-year requirement. So the J2 spouse and children are also subject to that same requirement, even though they weren't here for GME. Obviously, they were here as dependents. Now, if a J1 obtains a waiver of the 2-year foreign residency requirement, then the J1 and also the J2 dependents do not need to return to the home country for 2 years. There are various types of J1 waivers, which we'll talk about in a little while, but that's the only way that they can avoid having to go back home for the period of 2 years. The J2 application process, very similar to the H4 process. Again, there are 3 ways. One is to obtain a J2 visa stamp through a U.S. embassy or consulate. If you're a Canadian citizen, you can skip over that. You don't need the stamp for your passport, and instead you can just present yourself at the border if you're driving to the U.S., or present yourself at the airport if you're flying in. Let's say you're flying from Toronto, you would be going to Pearson International Airport, and there is absolutely a U.S. Customs and Border Protection office there, and they will process your application for admission and actually officially admit you before you get on your airplane to fly here. So you land here in the US, you've already been granted a J2 status or H4 status, and you're all set to go. The last way, of course, is to change your status in the US from whatever visa status you currently hold, such as an F1 or some other type of status. Again, it does not result in a stamp, and that stamp is what you would need to enter the U.S. or re-enter in the future after a future trip abroad. And again, only a U.S. consulate or embassy can issue such a stamp in your passport. All right, and J2 with EAD. So I know a couple of minutes ago, we talked about H4 visa holders, spouses really, who could qualify to obtain an EAD or a temporary work authorization. Well, that's also true for J2 spouses. They also qualify to obtain an EAD. The nice thing is that unlike the H1 and H1B and H4 situation where you have to prove certain things, like the H1B has held H1B status for 6 years or has an I-140 approval, none of that is required in order for a J2 to obtain an EAD. Instead, just because the J2 holds J2 status, they're automatically eligible to apply for an EAD. there's only one requirement, and usually it's no problem to show this. And the requirement is that any income that the J2 person will earn is not needed to financially support the J1 spouse. So as long as that's the case, that's terrific. The J2 person can apply for EAD. The EAD, just like the H4 EAD, allows for employment with any employer and at any job, any location, any rate of pay, multiple employers, really unlimited opportunities in terms of employment, full-time, part-time, multiple jobs, etc. And this EAD, just like all of the other EADs, does have an expiration date. So it's important to be cognizant of that expiration date. A couple of minutes ago, I mentioned the foreign residency requirement, and I figured, I'll give you some information on this just so that you may have heard about it a lot. You may have wondered exactly what it means, what the requirements are, etc. So I figured we would spend a couple minutes talking about this requirement. Now, this is a requirement that is part of the J1 law. And as I mentioned, it does not apply to every single J1, but it does apply to every J1 who is in the US for graduate medical education. There is no one who would get a J1 for purposes of coming to do a residency or fellowship who is not subject to it. So it doesn't matter what country they come from. It's a blanket requirement. It applies to everybody, and there's no way around it. In contrast to that, certain other J1 folks, such as certain researchers and others, may or may not be subject to the requirement. And even if they are, it may be the case that they can apply for an easy waiver, which is known as a no objection waiver. Now, J1s who are here for graduate medical education, unfortunately, cannot take advantage of this easy no objection waiver. Instead, they have to go through a much more rigorous J1 waiver process, which we can touch on for a minute or two, but is actually part of a different Zoom presentation. So first of all, as I said, all GME J1s are automatically subject to this rule. And at the end of the training, at the end of their program, which can last no more than 7 years, the J1 and any J2 dependents are required to return to the home country. And again, the home country is the one that is listed as the country of last permanent residence on the DS 2019. So it's really important to review that document and know exactly what it says in terms of last foreign residence so that there's no problem of a person accidentally going to the wrong country for 2 years and thus not fulfilling the requirement. Now, if someone does leave the country and is fulfilling the 2-year requirement, it is possible for them to return to the US as visitors, whether it's for medical meetings or to take a trip to Disneyland or to see family. The only thing to note is that any time spent in the US as a visitor is added back onto the 2 years. So if someone comes for, let's say, a 2-week vacation, so they will have to spend 2 years plus 2 weeks back in the home country in order to fully and comply with the 2-year requirement. Now, as I said, the J1 person can apply for a waiver of the 2-year requirement, and if it's granted, the J2 is also, or J2s are also able to benefit from that waiver. So there are various types of J1 waivers, and I'll just mention some of them briefly. There's another Zoom presentation that gives much more information on the types of J1 waivers and the mechanics of those waivers. So things such as employment for physicians in a medical shortage area or at a VA medical facility, or for anybody, possible persecution if the person would face a well-founded fear of persecution back in the home country, or exceptional hardship to a US citizen spouse or US citizen child. Changing from J2 to other statuses. So this is something that I really wanted to focus on because the Immigration Service over the last several years has been inconsistent in terms of their policy, and they really seem to have a firm policy now, but for years they wavered back and forth. And I'll tell you what I mean in just a moment. But first of all, what we're dealing with is that the spouse, the main or primary spouse who's on the J1 is near to completing their program or near to completing their stay as a research scholar or in some other type of J1 job. So at that point, if the family wants to stay in the US or perhaps leave and then come back, it's important to figure out what can they do and what can the J2 change to in terms of other visa statuses. So first of all, J2 visa holders can change to H4 in the US if the J1 spouse changes to H-1B. So what we're assuming here is that the J-1 spouse has obtained some type of J-1 waiver, and that J-1 waiver allows them in certain circumstances to change from J-1 to H-1B in the U.S. So along with that H-1B application, the J-2 can include an application to change from J-2 to H-4. This is filed all at the same time in the same package, and both applications, the H-1B and the H-4, are normally processed and approved simultaneously by the Immigration Service. Currently, J-2 visa holders cannot change their status to H-1B in the U.S. And this is the subject that I was talking about, where over the last many, many years, there has been a back and forth with the Immigration Service, the USCIS, as to whether this is allowed, whether they will approve such changes, whether they will not. They really went back and forth for many years. There was a time where they would absolutely have no problem agreeing to change a J-2 person's status from J-2 to H-1B in the U.S. without making them leave the country. For the last number of years, maybe 6, 7, 8, approximately, maybe a little longer, the Immigration Service has instead taken the position that the applicable U.S. immigration laws actually do not allow the Immigration Service to approve such a change of status in the U.S. And so at this point in time, and really until something changes, if it ever does, a J-2 cannot apply to change to H-1B in the U.S. Now, that doesn't mean that they can't become an H-1B. It simply means that an extra step is going to be required. So here's what J-2s can do. They can change from J-2 to H-4 in the U.S. and then change from H-4 to H-1B. Or instead, they can change from J-2 to H-1B by actually going out of the country and applying for an H-1B visa stamp at a U.S. embassy or consulate abroad, and then returning to the U.S. So this is really not a change of status because the word change really means in immigration terms changing in the U.S., but instead it's a two-step process for a person who would like to get an H-1B as soon as possible and does not want to have an intermediate step of first changing to H-4 in the U.S. and then changing to H-1B in the U.S. So instead, what folks do is they'll have an employer file an H-1B application with immigration, with the USCIS. USCIS will approve it, but they will issue the type of H-1B approval notice that is known as a I-797B. So this is the type of approval notice that does not change a person's visa status in the U.S. Instead, it has to be taken outside the U.S. The person uses it in order to obtain an H-1B visa stamp at a U.S. embassy or consulate, and then the person can enter the U.S. As an H-1B worker and start working in H-1B visa status. So it really depends. Some people don't mind the intermediate step of first becoming an H-4, figuring that they're not in an immediate rush to become an H-1B and to start working. Other people, on the other hand, really don't want to take the time. They don't want to spend the time waiting to become an H-4 and then spend time waiting to become an H-1B. Instead, they would rather leave the U.S., obtain their H-1B stamp, and forego having that intermediate step of changing to H-4. Less common visas. So, I know we've spoken a lot about H-1B visas and J-1 visas. I mean, these are the visas that we see in the context of medical residents, medical residents, fellows, attending physicians, and some others. But I also wanted to indicate that, there are other types of visas too that this sort of subject comes up in terms of dependent visas. So the L2S. The L2S is the spouse of an L1A or L1B visa holder. So L visas are for intracompany transferees, whether they're executives or managers, or what's known as specialized knowledge employees. These are intra-company transferees. So just as an example, let's say Ford Motor Company in the US has an executive at Ford Motor Company Canada that they would like to transfer to the US. What they can do is obtain an L1A visa for that person. That person will enter the US as an L1A, and the spouse will automatically be given L2S status. Now, the nice thing about L2S status for the spouse is that allows the spouse to work in the US, any job, any employer, any rate of pay, etc. So it's that letter S that comes after the L2 that is really the person's employment authorization. years ago, an L2 actually had to apply for an EAD card, much like the J2 or H4 people had to. Then the Immigration Service reviewed the existing laws and regulations and came to the conclusion rather recently that actually the laws allow an L2 spouse to work in the U.S. without the necessity of taking the time and expense of applying for an EAD card. And so what the service started doing is to add the letter S at the end of the L2, and that designation allows U.S. employers to go ahead and start employing L2S spouses without the need for an EAD card. Now, children who come with the L1 are not granted the L2S, they're granted L2 because children are not allowed to be employed in the US. So similarly, other visas, such as some of the E visas, E1, E2, E3, as you can see, there's an S at the end of each one. These are for spouses of E1, E2, E3 visa holders. And like the L2S, they can be employed in the US at any job, any employer, etc. Their kids cannot be employed. They would be granted the E1, E2, E3, not allowed to be employed in the US. But again, like all the other spouses, the H4 EAD, J2 EAD, L2S, spouses holding E1S, E2S, E3S can work anywhere in the country, any job, one job, multiple jobs. It's very flexible. And again, like all other visas, these visas all have an expiration date, whether it's an L2S, an E1S, etc. So it's always important to know when the expiration date is and to make sure that renewals are filed on time so that there's no interruption in the person's visa status and hence no interruption also in their ability to work in the US if they choose to do so. So if anyone has any questions, I'd be happy to answer them, or as always, feel free to email them to me, and I will have my contact info up in just a second. But just as a quick note about next month's presentation, we'll actually be getting close to the start of fall at that time, and we're going to be talking about the Diversity Visa Program. Now, that's a mouthful, but let me break it down into two words that you probably have heard before: visa lottery, or three words, green card lottery. So yes, you may have heard about the green card lottery, and there actually is such a thing, and it's called the Diversity Visa Program. And I look forward to giving you information about the program next time. It's a very interesting program. It grants up to 50,000 green cards per year to people from foreign countries that the U.S. Immigration Service considers to be underrepresented in terms of the number of green cards and the origin of green card holders for green cards that are issued each year. So in other words, these are not people from places like England, Germany, or France, but other places, Croatia and other countries that the US government believes may be underrepresented in any given year in terms of the number or percentage of green cards that are issued to everybody else. So we invite you to join us on September 19th, same time, same place, to learn more about the Diversity Visa Program. And in the meantime, if you have any questions, again, I'm happy to answer them now. Or if you prefer, please feel free to email or call me at any time. I'm always happy to hear from you and to answer your questions. And let me see, any questions? Okay, great. Well, I know there are no questions. At this point, I'd like to thank you all very much for joining us today. Appreciate you spending your lunchtime with us. I hope you had a nice lunch. And if you're in Michigan, I hope you're enjoying the nice weather or enjoying the weather wherever you may be. So thank you again, and look forward to seeing you next month. Thank you very much.